Good evening, everyone. Welcome once again to Legal Time with Connaughts. We're very excited to see all of you again after a long break. It's been a couple of very busy months for the firm as a whole and for us. So we apologize that we have not been consistent. We'll try our best to be consistent from now onwards. There is a lot been going on since we met last time.
Yes.
Shariar again is with us. Welcome, Shariar.
Thank you. Good evening, everyone.
A lot of recent developments in many areas of immigration. A lot of case laws have come in. We have some of our further updates to give you. So let's start straight away, Sharia. I think we should start with re-entry ban.
Yeah, I wanted to start with something for which we've been getting a lot of inquiries, and that's to do with re-entry bans. If someone's had an application refused, or there's been a breach of a visa condition, they want to leave the country. One question they usually have is that when can I reapply, when can I come back? So basically, the starting point is that if you leave the UK within 30 days of any application being refused, and you leave voluntarily, so you've not overstayed for more than 30 days, then the good news is that there's no re-entry ban. Now this also recently changed. It used to be 90 days, but now the law is that if you've left the UK within 30 days of your administrative review, of your appeal ending, of your 3C leave finishing, then there's no re-entry ban and you can actually go back and make any form of application.
I think even if you challenge via judicial review now, straight
Yes.
away after the refusal, if judicial review is refused to leave within 30 days of your judicial review being
Yes.
refused, which is something very new.
Yes,
Yeah.
correct, that's true. And then moving on, the 1 year ban. So the 1 year ban is basically where you have overstayed for more than 30 days or where you breached a visa condition. Good example is if a student is found working in violation of his rights to work and you've left then voluntarily after the Home Office encountered you, you left voluntarily and there was no expense to the Home Office, then there's a 1 year ban. So I think that's the important one where there is confusion for people who have left the UK after overstaying for more than 30 days or having breached a visa condition. Let's say they've come on a visit visa and they've been working. So for all those people, there's a 1 year ban after which they can make an application, which will not be automatically refused. Then there is a new concept which has been around for some time, introduced sometime in 2014, I think, of a 2 year ban. Now this is for people again who've overstayed or breached a visa condition, but then they've left the UK voluntarily within 6 months. So the way it would have worked is that you breached a visa condition or you've overstayed, but you stay on in the country. Then the Home Office serves you a notice that you have to leave the UK, which is usually something called a Red 1 notice, by which they tell you that they're going to remove you unless you leave. So as soon as you get such a notice, you pack your bags and you leave the country. So if you've left within 6 months of having received an official notice from a Home Office, then it's not a 1 year ban, it's a 2 year ban. So basically in the first one there's no notice, and the second one the Home Office tells you that we know you're in the country, we know you've been naughty, you've been working in breach of your visa conditions or you've overstayed, then you leave the UK 2 year. Moving on to the harsher then, if the Home Office then actually takes some steps and removes you themselves at their own cost, which means they purchase the ticket, they put you on a plane, they detain you, then it's a 5 year ban. So that's the most serious one where people who've been encountered, they've been removed. It's a 5 year ban. You make an application before that, they're going to automatically refuse you. And the most serious one, which I hope will be least applicable to applicants, is the 10 year ban, where you've been removed or deported from the country. Deported basically means as a consequence, or removed or deported as a consequence of a criminal offense. So that's a deportation, because most people typically get subjected to administratively removed from the country. So that's not a 10 year ban. But if you've been deported, then it's a 10 year ban. So those are all the re-entry bans. If you have more questions and if you have a specific set of facts, then email us and we can tell you what's the re-entry ban for you. I think you wanted to mention the spouses and human rights. Yes.
No, go ahead.
Just one summary towards the end is that people who make an application, a future application under Appendix FMs, which is under any human rights category, or they make an application for leave to enter as a spouse of a British national or a European national, any application where there's an implication of human rights, for those, these re-entry bans are irrelevant to them. These do not apply. So don't think that if you're married to a British national, you cannot make a fresh application. You can. So that's something to mention. Yeah.
It's just to say that there is no mandatory ban in these circumstances, but obviously your immigration history will be considered when entry clearance officer makes the decision. By the way, those of you watching us live, please make sure you post your questions. We can see a lot of people watching, and we'll be happy to take live questions as well. Sharia, long-awaited decision, Tier 1 general matter.
Yes.
Biology Gari.
Biology Gari, yes. So long awaited, of course. I think a lot of people are claiming it as their success, and I think it was success for all immigration lawyers, for all practitioners. Everybody's been literally challenging it for the last 2 years to say that Tier 1 generals and HSMP applicants whose applications for indefinite leave were being refused as a consequence of discrepancy in their tax returns, that the refusals were unlawful. I remember right at the beginning, and we were working together on the case, there was a refusal, and they had actually applied the what I still think is the correct section, which is 322 1A, which was to say that these documents are fraudulent and we're refusing your application. Now that was correct, fine. If the Home Office suspected dishonesty, they had to apply the correct section. But of course they were smart about it. Soon after, when we started challenging these, and we challenged a case by judicial review, they realized that the burden is on them to prove the deception. So very smartly they withdrew the refusals and started refusing them with reference to 322.5. And the good thing about 322.5 is that the burden was not on the Home Office. It was simply an assertion that we think your conduct has been dishonest and therefore we're refusing your applications. So all along we saw that there was something wrong with these refusals, but unfortunately most of these did not carry rights of appeal. Now cases which were being refused with a right to appeal, and these were cases where applicants had also completed 10 years,
and varied their applications.
So they became a SETLR application. So they were getting a right of appeal, but the Home Office, given that they were frustrated, they knew that they wanted to apply 320 in some form. They were applying 322.5 to those cases as well. But what we were saying to applicants, and what is pretty much public knowledge, those appeals were predominantly 90% successful because the judge understood all of these factors. And when he looked at all the evidence, when he heard all the evidence, those appeals were almost always allowed. The sad cases were the ones where there was no right of appeal, there was only the administrative review because the applicant had only been in the country 5 or 6 years. So then in those cases what was happening is these cases were going up to the upper tribunal for judicial review, and regardless they were meeting with less success, because in a judicial review it's not about the evidence, it is more about consideration of the papers and the law itself. But these cases, the cases of Balaji Gari and others, found their way all the way up to the Court of Appeal. And what the Court of Appeal has now decided is what we were saying all this while, is that yes, you cannot really, of course what the Court of Appeal says is that you can actually refuse these applications with reference to 322.5, but technically speaking the Secretary of State has to give applicants first an opportunity to provide an innocent explanation. To basically, what they were saying is you can't just refuse an application on an assumption of dishonesty. You need to establish that there has to be dishonesty first. So which is literally what we were saying, but in different words, to say that an applicant should be interviewed, or applicant should be asked to give in more evidence. Applicant should be given an opportunity to explain how their human rights would be impugned if such an application is refused. So which means all said and done, it's a case of the Home Office putting the cart before the horse. They've refused applications, only an assumption of dishonesty, not really having concrete evidence of dishonesty. So what we would say is that it's good news for applicants who are still waiting for their day in court. But for those of you who have actually had their refusals, even judicial reviews dismissed, you now have an opportunity to write to the Home Office to reconsider your case in light of Balaji Gari, which I think
this is in those cases where judicial reviews have been refused and there has not been any further movement in their cases.
Correct.
In those cases, they can still contact the Home Office.
I mean, what I've seen traditionally, what's happened is that those applicants have then given up their fight for indefinite leave, and wherever they have children or they've been in the country 7-8 years, they made fresh applications, FLRFPs or anything else, for leave to remain. So it doesn't mean that because they back in the day had a right to a judicial review and they lost that they can't go back. That's probably what the Home Office might say to these applicants. But again, they should write to the Home Office with detailed reps and explain that how they were denied the right to give an innocent explanation. Give that innocent explanation now and ask them to take a fresh decision. Once they take a fresh decision, if they refuse, then they have to, following this, give you a right of appeal.
Excellent. So it's a very good and promising news for those applicants, even if they had their judicial reviews previously refused and there wasn't any movement in their cases. They can still make further applications or representations to the Home Office and ask them to reconsider their matters. And for those who have had these cases pending or stayed against this case or otherwise, I think their solicitors have been periodically contacted by the Home Office and asked them to provide further evidence. A lot of our cases, Secretary of State has asked for extension of time in serving their acknowledgement of services. In that case, we're just waiting for the replies at the moment and accordingly build up our strategy on that matter. So if you were one of those who were affected, please contact your solicitors. If you need our help, our contact details are on your screen, so you can contact us anytime.
I mean, just a word that I wanted to add is that if you're making fresh representations to the Home Office for reconsideration, there is still some misunderstanding of the case of Balaji Jari, and it's not a question of writing to the Home Office to say, you applied 322(5) on my case, it didn't apply, look at my case again. No, that's not it. That's not what the Court of Appeal has said. It's complicated. So really and truly, you need to provide your detailed representations need to go to the Home Office, and that's only why they will reopen your case and give you a right of appeal.
It could be in form of another human rights application.
Yes.
We have done it in many cases related to TOEIC, for example. It's more or less the same test court has suggested.
I mean, if we go back to the case of Essen, essentially, I think that's exactly what's happened here. In which case, again, what they were saying to the ETS applicants is that you tell us how your human rights are being affected. So what applicants, these 322(5) applicants or Tier 1 applicants need to do is they need to set out the history of their case. They need to, of course, highlight the fact that 322(5) was then applied to their case wrongfully because they were not given an opportunity to provide an innocent explanation. And then they need to provide the innocent explanation, and then they need to talk about their human rights. So that's a complete package. So even if they refuse you, they give you a right of appeal this time.
Excellent. Thank you, Ahmed Sharia, for your very valuable input. Moving on, next topic we want to discuss is derivative right applications. There was very promising news when the Home Office introduced these new regulations on 29th of March this year, that derivative right applicants will fall under this new EU settlement policy.
Route to settlement.
Route to settlement. So previously, derivative right applicants did not have any recourse to indefinite leave to remain. So you could stay on derivative right until child reaches the age of 16, and after that you will have to find another way of staying in the UK. Then Home Office introduced the settlement scheme on 29th of March, and this was brought into that scheme that if you have lived in the UK on derivative right for 5 years, you can make an application under settlement scheme. Unfortunately, soon after, I think on 2nd or 3rd of May, they changed the guidance for derivative right, where it was specifically mentioned based on a case law that was decided some time ago, that anyone who wants to apply for derivative right, they will have to, there's a specific category in it which is Zombrano, where you have a child who's a British citizen, and parents are applying on the basis of the fact that they are primary carers of that child, or a single parent is applying on the basis that they are the primary carer of that child. In that case scenario, most of the time there is an overlap with Human Rights Article 8 or Appendix FM. Secretary of State has suggested they have made it part of their guidance now that anyone who is making application for derivative right, they must have been refused under immigration rules previously, especially under Appendix FM. And most of these cases, if you have a child who is a British citizen, you will have your Article 8 rights to family life engaged in the UK. Most likely than not, you will get your visas. So it's almost as if Secretary of State has put a block to those applicants who had a child who is a British citizen in making these derivative right applications.
Correct.
Because derivative right application is very cheap, fee is just £65, whereas human rights applications are 1,033 plus health surcharge for £1,000 approximately. Is a lot of money involved. And I understand that you have a case in Supreme Court. Hearing was on 7th of May. It's a huge case in Supreme Court. So Sharia, do you want to?
Yeah, I mean, the case is of course an extension of the principle of Zambrano, and in summary, of course, right now you're able to make an application for derivative right of residence if you have a British child, if what we seek to achieve is successful, and as a consequence of that, if there's a set of facts where the parents are British but the child is not, and the child is actually overturned 18, so what we're trying to do is that we're trying to reverse the principles of Zambrano to say that if there's a non-EA national over 18 in the country who's caring for ideally direct family members, in this case parents, then he should be allowed leave to remain. So it's an exact horizontal opposite of what the Zambrano principles say. But what we're also seeking to do is that we're trying to sort of extend the question of what is called the test of compulsion, because of course if there's a child then and the parents are British and the parents are leaving, or the father or mother, the sole responsibility is leaving, then the child will be compelled to leave because he is a child. But where we're talking about an over 18 direct family member, then they're looking at something called the direct or the test of compulsion, which is whether they would be actually forced to leave or whether it would be a choice that they're leaving as a consequence of their close family member being removed. So, of course, we had 5 Lord Justices and Baroness Hale who heard the case. It's gone well as far as we think. We've had 2 major charities or pro bono organizations working with us as well on that case. We expect a decision about 2 to 3 months, and of course it would be big news if successful, and you'll all hear about it. But talking about what Owais was saying, presently as things stand, the test for derivative right of residence has, or the guidance has changed, and what applicants are being forced to do is that they have to make an application under the human rights law. And I think it's an economic point, as Owais said, because if you make an application under the immigration rules or with reference to Article 8, then you have to pay about £2,000 to the Home Office, all inclusive. Whereas if you make an application on a derivative right of residence, it's a cost of £65. And what we've noticed is that the case they're relying on is an old case. It's not a case which has come this year or last few months. So the guidance can only have changed because they realized that everybody deviated from making human rights applications once this became a route to settlement. Before, they didn't need to do anything about this because everybody wouldn't make an application on a derivative right of residence because there was no route to settlement. As soon as they announced on 29th of March that this will lead to settlement, everybody started making applications in that route, and now they've come up with this guidance to stop you and put you back there. So this could be an interesting challenge as well, because I do not think that's what the Lord Justice meant in that particular case. It was more about really exhausting all remedies, and it was more about having tried to leave, to stay in the country under domestic law, but not really that if someone wants to make an application on the grounds of EA regulations, that he has to be forced to make an application under domestic law.
I mean, the I don't remember the exact wording. It was something similar of saying that it's not a back route to circumvent immigration rules.
Yes.
And Home Office has built up a whole policy just on that one comment, which is less than probably 2 lines.
Yeah, I doubt that it is what is meant in the policy guidance. I mean, talking about the policy guidance, I think going off this topic, what the Secretary of State says is that if you judicially review an application and as a consequence of that they withdraw the decision, your 3C is not reinstated or resurrected. So we've had cases where applicants have made in-time applications, so that means they were on 3C, applications refused, so no longer 3C, went for a judicial review was successful. So while the application was being reconsidered, we would ask them to, in EA applications or otherwise, reinstate the applicant's right to work, or say that please confirm that the applicant now has 3C if he is completing 10 years. The Secretary of State actually, even now in a judicial review, taken the position and they've referred us to a policy guidance to say actually 3C is not resurrected. But the point they're missing is that they have drafted the policy guidance. It's not an act of law, it's not a statutory instrument. And so what the Home Office says in their guidance doesn't have to be necessarily correct. It can be challenged. It's been challenged in the case of Alvi, where the Court of Appeal said that everything said in the guidance, anything which has a consequence of refusing an application is a serious thing and has to be law, not guidance.
And for derivative right applicants, important point is under 2016 regulations, there is nothing to suggest that you will have to exhaust remedies under the domestic law first before you make this application. So guidance is not really reflecting the regulations itself under which derivative right comes out.
Absolutely. So, I mean, that's a completely separate, altogether strong point to argue that that's not what the regulations say.
Exactly. And so most likely this will be challenged. I think we have some cases in the pipeline where we will be challenging this particular issue, and hopefully other firms will challenge that as well. So we'll see how where the case settles.
Of course.
Next topic we wanted to discuss was just to touch upon these new categories that have replaced tier 1 entrepreneur and graduate entrepreneur. We have discussed this previously as well. At that time it was very new, so we have a lot more information now as to how to proceed with these categories, whether it's like in one of the bloggers said, even viable or not.
Yes.
So Sharia, starting with startup.
I think there's a very interesting, as you said, a blog or a write-up on free movement. It was up sometime this week on these innovator and startup visas. So what's really and truly happened is that number one, tier 1 entrepreneur is clearly dead. This is not a replacement. This is a completely separate category. What's being advertised, unfortunately, not in the UK but abroad, is that the tier 1 entrepreneur route has become easier. Applicants only need to show access to £50,000 now, and I understand a lot of applications are now being put up abroad. That's not how the Home Office is looking at things, because what they now expect you to do is that you need to submit a business plan which has the endorsement, or let's say the whole entire application has been endorsed by an independent body. And of course we've got the 16-18 bodies that they've listed out on their website. Curiously, I don't know if you know, but one of the bodies actually was contacted by an immigration solicitor, and they said, we don't know how our name ended up here, and we've actually written to the Home Office to get our name removed. Because so what the Home Office has done is that they've put up a list of these bodies who would invest in organizations, but the semantics are so different from what the tier 1 entrepreneur route was. So going off topic, what I was saying is that this route is entirely separate. The requirement is that you must have an endorsement of your business plan, and you get that as a consequence of contacting these 16-18 bodies. And or for startup visas, which replaces graduate entrepreneur visa, is that you need an endorsement from your university, a body which is in receipt of higher funding. I believe that will be easier because you sit down with your counselor, with your visa officer, with your university supervisor, you discuss your business plan, you provide it to them, and if they endorse it, of course, with the condition that that the plan is innovative, then that's one thing. But for applicants who are sitting abroad, it's almost impossible, because most of these innovative bodies ask you to have a series of meetings with them. That's not going to be possible, because if you do that on a visitor visa, you would be breaching the conditions of your visit visa. You would need to come down on a prospective entrepreneur visa to come and see these individuals, these bodies. And then for a prospective entrepreneur visa, you again need endorsement. You need a letter from one of these bodies. So effectively what the blog that I was reading writes is that it's definitely closed for entry clearance, and for applicants who wish to make an application for leave to remain, it's going to be very, very difficult. What's your take on this?
Well, I agree completely. I mean, number of endorsements are very limited as well. I think it's around 200 endorsements so far for between the list they have produced. That's for the whole world.
Yes.
So inside the UK and outside the UK, so it's very limited. And many of the bodies that have been contacted, they have not even opened their endorsements as yet. Some of them are opening in July, some of them in June, and a lot of them don't even know how to proceed about it, because they don't have. Some of them, like you rightly mentioned, don't even know how they ended up on the list, and now they're trying to explore how to proceed about these endorsements, because they have to provide endorsements, not just initial endorsement, but every 6 months. So you have 6 months, 12 months, 18 months endorsements. So you rightly said, it's very difficult. I think almost closed for entry clearance applicants.
Yes.
In-country applicants will be extremely, extremely difficult. Therefore, we discussed another category, and that takes us to our next topic. We discussed this category before. It used to be a type of category not too many people know about, but it's becoming a lot popular. Sole representative of an overseas business. We've discussed it before, but if you can just explain it a bit more.
So basically, I mean, what you could call it in simple terms is a branch office visa, which means that if you have a business abroad outside the UK and you wish to set up an office in the UK, I say branch office because you cannot move the head office to the UK, so the head office still has to stay abroad, and you intend to start trading or you have an interest of setting up an office in the UK, so you can then select a senior employee of your organization. Again, another caveat is that the owner of the business cannot send himself. You cannot be a majority shareholder, but what you can do is that you can send a senior employee of the company along with the entire family to the UK to set up this branch office. There is no requirement of having access to a fixed set of funds such as 200 or 50,000 pounds. You just need to show that you're financially able to afford this venture out into the UK according to what your business plan says. And that's the core requirement. The English language test requirement is less tougher as well, and there is no maintenance requirement. So it's a much easier application to make with reference to the requirements themselves. But of course, for most people who are entrepreneurs, strictly speaking, then they cannot send themselves. It would only be their employees who can come and set up an office here.
Excellent. I mean, you can have a guess that even entry clearance officers did not know exactly how to, assess these categories. Now that more applications have been made from abroad, where we had a refusal where someone I know had a refusal, it wasn't us, where test applied was not for this category, it was a totally different test where they refused the application on the basis that it may not be a genuine business and some issues with the employment, etc. So it wasn't something that was part of this category.
Correct.
So it's very strange that even entry clearance officers were not trained to deal with these type of applications. But it's an excellent category. If you have a business set up and you want to set up a branch like Sharia mentioned in the UK, you can send your senior employees to the UK to set up a branch and basically have.
Classic cases of many individuals, particularly from India and Pakistan, who are trading with the UK, textile companies, for example, and
sports goods.
So they're supplying to the UK, and they feel it would be good to have an office in the UK, whether it's for stocks or whether it's for taking orders, all those sort of things. It's an excellent visa. I was recently assisting textile owners who are trading heavily with Marks and Spencers and Primark and so on and so forth. So they really and truly just needed a presence here, an office here. So that's the perfect category for such a case. Instead of applying under entrepreneur or any other route, and you don't need to think that now you don't have a way into the UK. So you just use the sole representative visa category to make such an application.
Excellent. We have some live questions as well, which we will take in a minute. I just wanted to touch on one more category area. As you know, we recently had a permission granted on stateless applications. It was, for some time, it was a norm that any applicants who are under the age of 5 and not making an application for nationality being stateless after the case of MK were being refused.
Yes.
Now that we have this permission granted, by the way, in this case, applicants' parents were Indian nationals.
Yes.
I think it is a promising prospect for those parents who have children who are under the age of 5,
yes.
But stateless at the same time,
yes.
to make applications. Home Office has changed the rules now after 29th of March, so they have made it more stricter, even though they have lengthened the time of visa, which is from 2.5 years to 5 years in this category, yes, for leave to remain. But the requirements to test is much more stricter now, so yes, they will have to show that they have tried their best and they won't be registered as yes, nationals of that country. So the letter from the High Commission saying that they are not registered won't be enough anymore. Yeah. They will have to show that they even if they try, they cannot be registered.
Yeah.
And this was the case in the matter we dealt with, and let's see how it goes.
Yeah, you've been granted permission.
We have been, yes.
Okay.
Yeah.
Okay. I think for viewers, to simplify it, for individuals who are making applications after the child had been in the UK for 5 years, the test was that they had to see that the child had been stateless for 5 years. So that's why they were not forcing, or at least the case of MK did not envisage that applicants should actually go and get a letter which says that they made their best efforts, because by that time the child has already been in the UK for 5 years. But applicants where the child is not 5 years old, let's say 2.5 years old, for them they cannot apply on the basis only of having a letter to say that the child has not been registered, because that means he still can be registered. So such applicants would need a letter to confirm that they cannot be registered, or they will need to demonstrate by any other means that they've made their best efforts, child cannot be registered.
Excellent. Thank you very much. We have some live questions. One of them is a straightforward one. Is medical insurance needed for European spouse visa applications? I think it's only in the case when you're showing either you're self-sufficient
Yes.
or you're a student. So you're relying on your student income or self-sufficient, you require medical insurance. Otherwise, it is not required. You just
No.
need to show that you're exercising your treaty rights in one way or the other. Question, as I always say, our program is not complete without a question on 7 years policy. So we have a question on 7 years policy. We have, by the way, few programs on this topic in detail. So if you want to have more detailed information on 7 years child policy, where child has reached 7 years under the age of 18 in the UK, you can go through those programs and get better information regarding this topic. But just to briefly comment on this.
What was the
7
question?
years.
Sorry, the 7-year route. Yeah.
Someone's asking about 7 years route. That's it.
Right. Well, the 7-year route in simple words is that you have a child who's under 18 who's completed 7 years in the UK, and of course those are the simpler requirements to meet. But then there's the final limb of that, which is that there must be exceptional reasons as to why the child cannot be sent back. So, which means that the Home Offices have left themselves a little door as always to refuse applications, even if the child has completed 7 years. But in our experience, the most successful applications are where you submit evidence to show that the child would actually face difficulties in resettling or settling for the first time back in their country, and that is with the support of independent social worker report, independent psychological report, letters from schools or from the principal or from their close family members who are settled in the country, to all combine and show that the child is strongly integrated in the UK, has a private life here, and as a consequence of that cannot be sent back. What we've seen is a recent trend is that back in the day, combined family applications would be made, and those applications would be usually refused with a right of appeal. But this year in 2019, what we've seen is that the most successful applications are where the child makes an application on their own as an applicant, and once the child has been successful, the parents follow through and make their own applications. So that's the 7-year rule in a summary, but of course every case has their particular set of facts. We've recently been successful in a case where the child was only 5 years old, but the child was autistic. So of course autistic children are heavily affected by change. If you change their environment, and in this case if you're changing their entire social surroundings, the best interest will not be served, and that's why the judge allowed that case. So every case turns on their own particular facts. So get in touch with experts and they can tell you more about how to make the cases stronger.
I mean, in these type of cases, key is to provide evidence to show that child it's not in the best interest of the child to be removed from the UK. And like Sharia mentioned, we've been successful even where child was 5 years old, but in that case there was a lot of professional evidence available to show that it won't be in the best interest of the child. So as I said, we have more videos on this. If you want further information, you can watch those videos. If you have any questions, you can email us. Details are on your screen. Shira, I've got another question. I'm assuming it's basically says law about family, mental illness, abuse, etc. I'm assuming it's to do with staying in the UK for medical reasons.
Yes.
And I understand that you have some expertise on these type of matters.
Yes, but in simple words, it's your reference is to Article 3, which is basically to say that you would not receive adequate medical treatment back home where you would be removed to. It's a very, very, very high test to satisfy, and in a case which follows through in an old case, the precedence is that the condition must be so serious that as a consequence of you getting on a plane or before you get home, if there's an interruption in your medical treatment, you would die. So that's the test. So where applicants
so basically you take the plug out and
you're on life support, essentially speaking. So where anybody, I don't mean to be harsh and unsympathetic to anyone who's being treated for depression or any form of serious medical illness. The tragedy or the benefit to the Home Office is that treatment is predominantly available throughout the world, but in particular where applicants would apply from, whether it's from Africa or whether it's applying from Pakistan or India, treatment is now widely available. So there isn't really such a case where you could prove that you're, of course, by all means, if you're able to show, if your GP writes a letter, if your doctor writes a letter that you are part of a test case or you're taking particular form of medication which is not available outside the UK, you will most certainly be successful under that treatment. For example, we were recently successful for an applicant who's part of a pilot study for cancer patients. Now that's a 1 year study and he's been selected by the NHS and he's on that. So of course he's been given leave to remain because he's part of something which is not available outside the UK. But if otherwise you're under any form of mental health care, then the Home Office is unlikely to approve such an application.
Excellent. Thank you very much. I think that is it for today. Do you want to discuss something else? Or?
No, I mean, just on that note, if there's any confusion and if the question is that if that person is here on a spouse visa and if such a person has been subjected to any form of mental or physical violence, then of course there is a route to settlement which is called settlement by virtue of domestic violence. Of course, I think we should dedicate a particular section of a program next week to that and we could talk more about it.
Yeah, excellent. So stay tuned for next week and we will be discussing cases regarding domestic violence, both under immigration rules and the EA regulations. So I think this is it for today. Thank you very much for those who watched and posted their questions. If you have any questions, you watch this video later on and you have any question, please email us. You have our details on your screen. Email us, me, Shehryar, or our team, and we'll be very happy to help you. In the meantime, as I said, it's been a while since we restarted this program now, so we will try to be more consistent.
Definitely, yes.
And if you have any questions, please send us those questions and we'll try and address it in our live program if we can't answer it directly before that. And thank you very much for attending.
Thank you.